Hello and welcome back to It Feels Like All Delphi All the Time. But we have defendants counsel. So these are the defense lawyers counsel for the contempt hearing. And this is you know, pound sand, Randall and Judge Gull kind of emotion. So I figured I'd do a quick, short, and in a hurry ish sort of video, let's hope. Plaintiff or State of Indiana plaintiff versus Richard Allen defendant. Defendant's counsel motion for summary. Sorry. English is my first and only language, and I still can't do that right. Denial of state's verified information for contemptuous conduct. Counsel for defendant Richard Allen and Andrew Baldwin and Bradley Rossi by counsel come now before the court with their motion for summary denial of the state's verified information for contemptuous conduct information filed on January 29th, 2024. For the reasons that follow, the court should summarily deny the state's information. Now, I doubt in her infamous or in her infinite bias that Judge Gull will listen to any sort of intelligence that's given in this, but let's continue. Introduction. The state's information has many flaws, mostly because it was written by the state. Look, I have no chill for these people anymore. I really don't. Not the least among them is its failure to allege, either directly or by inference, either Mr. Baldwin or Mr. Rossi committed any of the supposed offending acts willingly. See Indiana Code subsection 34-47-3-1, defining indirect contempt as, quote, willful disobedience of a court order. But the state's information has two additional flaws that are fatal. First, to the extent that the state's information purports to allege indirect civil contempt, it fails to allege any act during injuring the state that a remedial or coercive contempt sanction would redress. The state therefore lacks standing to pursue its information as one for indirect civil contempt. So basically, you don't have subject matter jurisdiction. And this court lacks jurisdiction to consider it. Second, because there is no available remedial or coercive contempt sanction, any contempt sanction would necessarily be punitive. Therefore, a finding of indirect criminal contempt. But to pursue indirect criminal contempt against Misters Baldwin and Rossi, the state would have to file its information in a separate criminal case. It has not done so, and this court has no authority to punish Misters Baldwin and Rossi for indirect criminal contempt in this criminal case against Mr. Allen. Let's look at footnote 1. This is a written motion required by the Indiana Original Action 2, subsection A, which provides in its relevant part, no petition for a writ of mandamus or prohibition will be entertained unless the realtor has raised the jurisdictional question by written motion which the trial court has denied or not ruled upon timely. The motion shall allege the absence of jurisdiction of the respondent court or the failure of the respondent court to act when it was under the duty to act. So there is no subject matter jurisdiction. Where is Daryl Brooks when you need him? Finally, were the court to impose without jurisdiction or authority to do so any necessarily punitive sanction on the state's information in this criminal case against Mr. Allen, it would be at least the second time the court has interfered with Mr. Allen's 6th and 14th Amendment rights to counsel. See Strickland versus Washington, 466 U.S. 66-6, 60, 466 U.S. 668, 683, 1984. Quote, the court has considered the Sixth Amendment claims based on state interference with the ability of counsel to render effective assistance to the accused. Citations omitted. Footnote 2. At least one other time, of course, was when on October 12th, 2023, in an email, the courts ordered Misters Baldwin and Rossi to stop their work on Mr. Allen's behalf for at least a week. State interference with counsel in violation of the Sixth Amendment is a structural error for which prejudice is presumed, e.g., Weaver versus Massachusetts, 582 US. So basically, this could be I do believe this could be an appealable offense, not a lawyer, if you will. Uh, Also, okay, presumed, i.e., Weaver versus Massachusetts. See also Strickland, Force 66 US at 686. Quote, the government violates the right to effective assistance when it interferes in certain ways with the ability of counsel to make independent decisions about how to conduct defense. End quote. Getters versus United States, 425 U.S. 8, comma 91, 1976, Sixth Amendment right to counsel violated without showing of prejudice for trial judges' interference with the defendant's right to consult with counsel. Notwithstanding so-called Younger's abstention, because it may not well apply, see generally Younger versus Harris, 401 U.S. 37, 1971. Further state interference with his lawyer could compel Mr. Allen to seek federal habeas relief under 28 U.S.C. 2241 subsection C, subsection 3 in the form of an injunction. Were Mr. Allen to prevail in that undertaking, a conditional writ of habeas corpus, though using more formal legal, and then let me go to the next page, language would look something like, quote, release Mr. Allen or leave his lawyers alone. But win or lose, federal court is not a railroad siding Chief Justice Rush likely had in mind when she said that sat at a hearing on a second original action involving this court case, quote, "My concern is getting this case back on track," end quote. Hearing January 18th, 2024 at, uh, I believe 2:25 state, so this is the actual, Supreme Court that just reinstated these 2. Like, I want to get this case back going on. Stop being a dumbass. The state's number 1. So, basically, like, y'all keep playing around. Y'all keep playing around. We're gonna bring the feds in, okay? Y'all just keep playing. We're gonna bring feds in, and then no one's gonna get to have fun anyway. Number 1, the state's information has not alleged any injury a civil contempt sanction can remedy. The state therefore lacks standing to pursue its information as one of civil contempt, and this court lacks jurisdiction to consider it. A. The state information attempts to allege Misters Baldwin and Rossi committed acts of indirect contempt. As a matter of law, almost older than dirt, there are two kinds of contempt, direct and indirect. Contempt of court generally involves disobedience of a court or court order that, quote, undermines the court authority, justice, and dignity. INRAS, and then it goes to cite on a lot of cases. There are two kinds of contempt, direct contempt and indirect contempt. ID, indirect contempt, which is at issue in this case, involves those acts, quote, committed outside the presence of the court, which nevertheless tend to interrupt, obstruct, embarrass, or prevent the due administration of justice. ID at 32, quoting Indiana law Encyclopedia Contempt, subsection 2, 1958. Reynolds versus Reynolds, 64 NE 3D 829832, Indiana 2016. It should not be a matter of dispute that the state's information at least attempts to allege that Misters Baldwin and Misters Rossi committed indirect attempt. None of the acts the state information alleges were contemptuous occurred in the court's presence, about which the court itself has knowledge. See Indiana re Nasser, uh, 644 NE 2D 63 96, Indiana 1994. Direct contempt depends on a quote, the judge possessing personal knowledge of the contemptuous act, citing Hopping versus State 637 NE 2D 2 or 1294 1297 Indiana 1994. B. Sanctions for indirect civil contempt must be remedial or coercive for the benefit of the aggrieved party. Sanctions for indirect criminal contempt are punitive. As a second matter of law, almost older than dirt, direct and indirect contempt each come into varieties, civil and criminal. Sanctions for civil contempt are, quote, for the benefit of the party who has been injured or damaged by the failure of another to conform to court order issued for private benefit of the aggrieved party. Again, they're quoting another state case. Dumbling versus Fort Wayne Community Concerts Incorporated, 1963. Sanctions for civil contempt also must be, quote, either remedial or coercive. And it's also citing Dumbling. State ex revelance. Look, y'all know I am not a lawyer. Quote, the objective of a the objective of, oh, for the love of Cheetos, Mo, read. The object of civil contempt is the enforcement or protection of rights of the complainant, and only a coercive or remedial judgment may be entered. End quote. Federal authority is no difference. See Goppers versus Sears, Roebuck and Co. 211 U.S. 418 44 or 441 1911. For civil contempt, the punishment is remedial and for the benefit of the complainant. On censorati to the District of Columbia Court Appeals, word look, there is a lot of citation of court cases that I am not a legal lawyer. Criminal contempt, on the other hand, is, quote, an act directed against the dignity and authority of the court which obstructs the administration of justice and which tends to bring the court into disrepute or disrespect, end quote. State versus Hetzel and all that, jargony stuff. Look, not a lawyer. Sanction for criminal contempt are intended to vindicate the authority of the court, e.g., Colwart versus White, Brown versus Brown, and all sorts of other states, all sorts of other cases with all the casity goodness that you could want. C. The state's information alleges no injury. A civil contempt sanction can meaningfully redress the state's resulting lack of standing to pursue its information means the court has no jurisdiction to consider it. Even were the court to take as true every allegation, the state's information, no sanction imposed for any of the alleged contemptuous acts would remedy any injury to the state, nor would it coerce Misters Baldwin or Rossi to comply with any order of the courts court the state's informations alleged they violate. See Indiana Code subsection 34-47-3-C or -5-C. Good Lord, Mo. What is wrong with you? Governing indirect contempt. Quote, the court shall, on proper showing, extend the time provided under subsection B, subsection 3, to give the defendant a reasonable and just opportunity to be purged of contempt. Emphasis added. Civil contempt orders avoid punishing the commentor by allowing the party to be purged of contempt. Citations omitted. The state therefore has no standing to pursue its information. Quote, the standing requirement is a limit on the court's jurisdiction, which restrains the judiciary to resolving real controversies in which the complaining party has a demonstrable injury. So basically, quit your whinging, Randall. Quote, only those persons who have a personal stake in the outcome of litigation and who show they have suffered or were in immediate danger of suffering a direct injury as a result of the complained of conduct will be found to have standing. Now, I can imagine that Judge Gull is going to twist this and say that the family of the victims were injured. Now, I don't know how you could do that legally as lawful law. I will have to get with Nick on this because I don't understand that, but I'm sure she'll find like they say in Jurassic Park, she'll life will find a way. Judge Gull'll find a way. Absent this showing, complainants may not invoke the jurisdiction of the court. Without injury, meaningful redress or without injury meaningfully fully addressable by civil contempt sanction, the state simply does not have standing to pursue its information, and this court does not have jurisdiction to consider it. Miller. Quote, because Miller did not have standing to bring his contempt motion, the trial court did not have jurisdiction and should have dismissed his motion. Accordingly, the court should summarily deny the state's information. Two, the state's information can only be seeking punitive sanctions for criminal contempt. The state filed it in the wrong place, and this court has no authority to impose criminal sanction in a criminal case against Mr. Allen. Huh. Well, I'm not a lawyer, so I didn't know that, but you'd think that, the prosecuting attorney would know such things, being a lawful law attorney, but, you know, it happens. A, without an available remedial or coercive sanction, any sanction imposed by the court, whether imprisonment or a fine, would be punitive, thus making the object of the state's information a finding of indirect criminal contempt. As a third matter of law, almost older than dirt, quote, a fixed sentence of imprisonment is punitive and criminal if it's imposed retrospectively for a complete act of disobedience, such as that the contemptor cannot avoid or abbreviate the confinement through later compliance. Bagwell, and look, a bunch of citations. Similarly, quote, a flat, unconditional fine totaling even as little as $50 accounted after finding of contempt is criminal if the commenter has no subsequent opportunity to reduce or avoid the fine through compliance. B, an information for indirect criminal contempt must be filed in a separate criminal action. As a fourth matter of law, almost older than dirt, if the state, by its information, is seeking punitive sanctions for indirect criminal contempt, it filed its information in the wrong place. Did you get your law degree in Guam? Asking for a friend, Randall. Quote, a proceeding for indirect criminal contempt must be filed as an independent action and must also be prosecuted by the state. Allison versus State XL or XREL Allison. Mark Kensling, uh, William, quote, William Hetzel and Mark Kensling were charged with indirect contempt of court in an information filed by the Lake County prosecutor. Uh, A charge of criminal contempt should be prosecuted by the state against the defendant in an independent action. So all of these cases are proving over and over again that the state A didn't file this in the right place, isn't following correct procedure, and there really is no there there. I mean, look, the state may feel very strongly that, the defense counsel did wrong, all the wrongness, but they can't. The information for a criminal contempt should be entitled State of Indiana versus the defendant and filed as an independent action and prosecuted by the state. In a separate action, the state charged Jones with indirect contempt under Indiana Code sections 34 47-3-1 and 34-47-3-5 for her failure to appear on October 7th deposition. C. The court has no authority to impose any punitive sanction for the indirect criminal contempt in this case against Mr. Allen. The court simply may not impose any punitive sanction for what could only be a finding of criminal contempt in this criminal case against Mr. Allen. That would amount to a conviction and punishment on the charge that the state has not made. The situation would be no different from that in McMinn. Quote, McMinn was convicted on a charge not made, which is a sheer denial of due process. Therefore, the judgment and commitment issued therein are void. Accordingly, for this second reason, the court should summarily deny the state's information. 3. Not only was the state's information filed in the wrong place, but as written, it also fails to make out a criminal charge. Damn, Randall, you're having a bad day. It does not allege Misters Baldwin and Rossi acted willfully, admitting a material evidence or a material element of indirect contempt. This is not remedied by any reference in the information to subsection 34 47 3 1, which defines indirect contempt as willful disobedience of a court order. Conclusion. For the foregoing reasons, Mr. Baldwin and Rossi respectfully tell you to pound sand. I mean, I added that part. Uh, Service of Michael K. Osbrook, Indiana University Mars School of Law, Federal Habeas Project. You go, sir. Look, there's nothing I like more than telling Judge Gull that she's a stupid dum dum. Well, and Randall. Now, I'm sure she will ignore all of this to say that, no, they're full of contempty contempt, that's all the contempties. It's full of contempt, and you are all contemptible. You are all contemptible. So, there you are. I'm sure that's what's gonna happen. I I don't wanna be black-pilled, but I feel like she's going to read this very or maybe not even read it, take it, crumple it up, put it in the trash can, light that trash can on fire, and throw it into the sun. But that's just my take on it. I'm a little down after reading, the Frank's motion because they had so much on these other guys and they just kind of ignored it, but I'm gonna have fun tonight. Tune in for Nightly Newsy News, because the Wheel of Wigs has picked Dude Guy for me to be tonight, so we'll see how this wonderful disaster is going to go. Anyway, we deal with tough stuff, we deal with tough cases. Sarcasm and cookies are welcome. Be nice to yourself, be nice to others. It's a rough world out there. Have a wonderful day. I will see you later. Stay nice. Bye, guys.